I'm very privileged to be here chairing this panel, which, as you can see, is the largest panel to date. Each of the panelists who I will introduce shortly are going to speak for about 7 to 10 minutes, which is a little bit shorter than the previous panels, but I want to make sure we get through and have time left for questions. So the panel that we're going to have now is a combination of both researchers and practitioners, people who are on the ground trying to make sense, trying to interpret what the research says. One of the complications is that the research that a lot of the academics produce isn't always translated into policy speak. So we'll be talking a little bit about the ways in which that can be improved in terms of best practices. But we're also going to be talking a little bit about some of the distributional concerns about licensing, which some of the earlier panels briefly touched on, but which actually can turn out to be very, very important and deserve more attention. So I'll just introduce the panel, and then we'll go from my left. Immediately to my left, we have Mischa Fischer, who is the chief economist of the state of Illinois and an advisor to Governor Bruce Rauner. And he has a background working as a legislative advisor in the U.S. Congress and in Illinois' Commerce Department. Mischa is a very big proponent of using data for evidence-based policymaking related to the state's economic issues, which includes occupational licensing. And he'll also be teaching a class at Northwestern University on this later. Past Mischa, we have Peter Blair, who is an assistant professor at the Harvard Graduate School of Education, as well as a faculty research fellow at MBER. He's both an economist and a physicist by training, which I thought was really neat, and a member of the University of Chicago's Human Capital and Economic Opportunity Working Group. And he studies the relationship between occupational licensing and inequality in education and labor markets. Past Peter, we have J.Gilman, who is an attorney advisor in the Office of Policy Planning at the Federal Trade Commission, where he focuses on issues of antitrust, regulation, and competition, particularly in the healthcare, pharmaceutical, and technology industries. And in the past few years, he has written about how licensure and scope of practice regulations in healthcare provider markets can affect consumer welfare. Second to last, we have Sara Markowitz, who is a professor of economics and director of graduate studies in the economics department at Emory, as well as a research associate at MBER. She is a health economist and has published dozens of articles, many focusing on the risky behaviors and the health of youth and how they are affected by public policy. More recently, she has studied regulatory barriers for advanced practice nurses and physician assistants in different labor markets. And then all the way at the end, but certainly not least, we have Albert Downs, who's an employment policy specialist with the National Conference of State Legislatures, with expertise in occupational and professional licensing policy in U.S. states. And jointly with the National Governors Association and the Council of State Governments, the NCSL is applying a grant, which we're actually just talking about, from the Department of Labor to study the extent of occupational licensing across the states, as well as how the occupational licensing affects worker opportunity, and thankfully how states may actually coordinate their policies, which is a nice first step. And with that, I will turn it over to Mischa. Thank you.
So thanks, everybody. I'll be the first to sort of preface, I'm really fortunate to be in the job I'm in. I think most economists are traditionally used to beating their head against the table, trying to get somebody to listen to them to actually change policy in a way that makes rational sense. One of my favorite anecdotes of this was apparently JFK went through his granted abbreviated presidency without ever learning the difference between monetary or fiscal policy. And I think that that's, his economists and, fast forward to today, almost 60 years later, are also used to being in an environment where you can really try and construct the best analysis with the best statistical methods and come up with a really, well-crafted, nuanced proposal. And then, of course, nobody's going to actually listen to it or act on it, and that can be kind of a frustrating experience. And right now, I'm extremely privileged in that we have a governor in Illinois who is himself from a quantitative background and is really focused on what is doing empirically the right thing, not necessarily on what's politically expedient. And so I get to wear the hat of both an economist who gets to dig into numbers and do original analysis and think about nonlinearities and interaction effects. But then I also get to put my fingers into the agencies and actually try and shape how we do things and change them a little bit for the better. And so what I'll try and do is highlight a couple of the different experiences that we've had in Illinois over the last couple of years in digging into the issue of occupational licensing and trying to make this issue of getting these, what are in effect liquidity barriers, out of the way so we can make the marketplace more efficient. And I'll do that by outlining sort of 5 different questions and answers that I think are going to be relevant to taking the experience we've had here and universalizing it to either other states, the federal government, or other countries even. And so those 5 questions are, first off, where do you look when you want to begin this process? And then the second one is, why are some things licensed and other things not licensed? What are the roots of these licensing issues? Who should you engage in that process as you're trying to build a coalition and answer meaningful questions? What should you say when you're trying to craft a policy message surrounding these things? And then finally, what does the roadmap for change look like? And so I'll start off by saying, let's look at, when you begin this process, where should you look? And I'm going to turn this mic on too, if that works. And so what you've got in front of you here is the very beginning of the process for us. Where did we look when we wanted to understand what did licensing look like in Illinois? And so the first thing you've got to think about is, well, where do these licenses exist? Sometimes they exist in local governments, right? There are local governments that license things. The city of Chicago licenses things. Counties license things. And then we've got a myriad of agencies that issue licenses. Some license, 1 or 2 things. Some license a lot of things. So we started the process by looking at our Department of Financial and Professional Regulation, which licenses the most things, but it by no means has a monopoly. And the summary stats you've got in front of you is just easier than having, unreadable histograms all over the place. And I think that the most important takeaway you can get from this is if you look at the summary stats, when we began this process, we said, let's figure out what the licensing universe looks like, and let's start trying to tackle this problem in a meaningful way. And what's really jumps out to me, at least, about these things, if you look at the distributions, I put the mean and the medians on there in terms of sort of the 2 most important moments of the distribution. And if you look at the administrative side, it's very uniform, right? The mean and the median are very similar. These are sort of pretty standard distributions. You don't have a lot of variance. But if you look at the characteristics of the underlying profession being licensed, suddenly a very different story manifests itself. So you can see we have 1.1 million active licenses across 228 license types when we began the process at the Department of Financial and Professional Regulation. And if you look at the cost and the renewal cost and the duration and the application length and the application questions and the application renewal times, all of those things, the administrative side, pretty uniform, right? So application questions, the mean is 24, the median is 22. Same thing with durations. All pretty uniform. But if you look at the things that capture the underlying characteristics of the profession being licensed, look at people per license. You have a mean of 4,700 with a median of 324. Right? That's an extremely skewed distribution. And I'll visualize that in a coming slide. But when you're looking at things, start off by thinking about it's quite an administrative exercise just to figure out where all these licenses are. We are still 2 years into this process discovering licenses that we didn't realize we issued. Because we'll go find some sub-bureau of some agency that licenses, some obscure practice that you didn't know about. And so, that's kind of the first thing is where do you look and how do you think about the things when you get there? And so you start looking at the distributions. And this sort of accompanies that question. This works better as a slide as part of a report than looking at it this far away. But this is a logarithmic distribution of the license types by various practice area. So within DFPR, we've got the health-related ones, the occupational ones, and then real estate as its own piece. And that's a logarithmic distribution. And what it captures is that it is ridiculously skewed in terms of the number of people being licensed by type. And that presents 2 challenges. Because if you're trying to fix this, you have to think about, am I trying to get rid of the total number of licensed types, or am I trying to get rid of the total number of people licensed? Because they are 2 mutually exclusive problems. Because if you go after a license that captures 10 people, you've had a significant reduction percentage-wise. I mean, it's a fraction of a %, but that's significant for government purposes, in the number of licenses. But you haven't really moved the needle on the 1.1 million. Vice versa, if you were to get rid of nurses, which are the most common one, if you were to somehow get rid of that license, which is not an administration policy, but if you were to do that, you would suddenly shave off like 10% of the outstanding population licensed, but you would move from 228 to 227 active license types. So it's an important distinction is to think about this difference in terms of what is the actual issue you're trying to solve. And then the final thing we thought was, how has this changed over time? So this is going back to about 1975, indexing that as 100. The smaller line is employment growth, and the red line is the growth in active licenses in Illinois. And so you can see they're dramatically different over time. And I think that that is helpful for understanding how this issue has changed. It's not necessarily part of a political argument, but it is a meaningful thing to look at as a policymaker. And so, moving on to the second question, why are some things licensed and not others? Let's think about this distribution again, right? So that's what it looks like in Illinois. But as we heard earlier, some things are licensed and some things are not licensed, and it varies dramatically by state. And this is where I think, to borrow sort of there's a lot of quantitatively inclined people in the room, and if you're thinking about trying to imply causation on something, you're making an underlying assumption about a deterministic trend that you can find. I think if your goal is to explain a large proportion of the variance between states looking for a deterministic trend, it's a fool's errand. I don't think you can do it. I think a substantial amount of the variance we see is random chance. My experience as a neophyte to dealing with the legislature in Springfield, I always joke that this is my first and last job in state government, and my experience has been that you can shape fairly impactful pieces of public policy based on the temporary social relations in terms of who's a contract lobbyist that's well connected, what the mood happens to be among legislators in a given week. I mean, it is so variable. If you're looking for a deterministic explanation for why some states do some things and some others, I think that will explain some of the variance, but I'm not even sure you'd get to an R squared of 50% in terms of explaining variance by looking for deterministic trends. So that's sort of a why do we see these differences question. I think the earlier explanation is the earlier explanation that we saw about some states being larger and better markets for, say, interior designers. I think that there's some truth in that, but you're not going to explain everything in that. Hopping along to who to engage, this is very straightforward. There's a unique political moment right now in terms of common cause that you can get with the politics of this, and that is recognizing that you've sort of got the libertarian right and the progressive left that are both concerned about both the unintended consequences of government and helping the traditionally economically disenfranchised. So the Institute for Justice and ACLU, and in Illinois, we've had a lot of success with the Safer Foundation, which is focused on getting ex-offenders back into the labor force as productive members of society. That's a really powerful coalition, so that's who you should engage if you're trying to do that. What to say and how to change, and what the roadmap for change looks like. I'll incorporate those two things for time considerations. We've been pretty successful in Illinois since we started this process 2 years ago. We've fully repealed 3 entire licensing acts with 11 licenses of 228 successfully eliminated. So it's a 5% reduction, which is about 5% more than I thought we would get. And we successfully joined this Department of Labor consortium of 10 or 11 states. That's a joint NCSL-NGA exercise. And so we successfully joined that, which has been a big win. And then in terms of a Sankey diagram, this is what it kind of looks like. You can see we skipped the health-related professions. I think that is a significantly harder barrier to address because you bring in so much of federal Medicare and Medicaid policy that you're going to have a really hard time getting short-term wins out of trying to change anything with medical licenses. But you can see we went after, of all the licenses at DFPR, we eliminated 11. We had one new one created by the legislature over a veto of the governors to license student loan servicers, even though they're already licensed by the feds. And then you can see what we've sort of proposed full repeal of, which was 23. We've proposed changing the durations of some, so you could take a 2-year license, turn it into a 4-year license. That's a winner. And then there's sort of 60 that for various reasons we've tried to avoid. And so that kind of wraps up my end of the slides. I'll just close by saying that, putting my economist hat back on, there are a couple of, I think, really helpful questions that we could get at in terms of what can the research community do to make this easier. If the language you're using to try and conduct these arguments is about rent seeking and monopolists and price increases, you're not going to get very far. That's not what sells the narrative. What sells the narrative is highlighting the personal stories of people who are locked out of the labor market because of this. And I think that there's two empirical questions that are open to being answered and then used to tell that story. The first is, over lunch we heard Dr. Gresham pointing out the disparity in incomes attributed to certain demographic groups associated with a license. But of course, somebody could use that and say, well, see, licenses are a good thing because that person's income jumped up. But of course, that's just the association behavior. And what that data speaks to me as, look at these professions associated with the license are ways for people in these traditionally economically disenfranchised demographic groups to suddenly earn $300 more a week or $400 more per week, but they're being locked out of that opportunity by the state. So that's the first thing. And then the second thing is, in terms of strictly statistically speaking, I think there's a lot of room to make good research-based progress on the interaction effects. So if you're thinking about sort of a traditional regression slope, it's your x1 times x2 as part of the formula. Like, what's the interaction effect? Because I do think that some licenses in some environments, you'd be really hard to identify a statistically significant bit of harm associated with it. But I think if it interacts with other characteristics of a demographic or a particular industry, then you could suddenly get these spikes in terms of how much harm can be caused by that in terms of limiting labor market liquidity. So on that, I'll give it over to Peter.
Thank you. I think that's a great.
The genesis of this project really started when we started thinking about, could licenses potentially be a labor market signal, in the sense that firms might face asymmetric information with respect to workers, and that asymmetric information could be related to the demographic characteristics of those workers. Women and minorities, perhaps because they've historically been locked out of certain aspects of the labor market, it might be more difficult for firms to assess their productivity. And so the question that we started with is, just like education is a labor market signal, could occupational licensing also be a labor market signal? A lot of the ways in which we as economists have traditionally thought about licensing is that it's a labor market friction. But in the Spence model of education, precisely because education is costly to obtain, and it's differentially costly by ability, it actually can function as a very good labor market signal. So that's kind of like the key idea that we went after in this paper. And so as a headline, so what do we do? So first, we looked at this really incredible data that Morris and co-authors were able to put together in the SIP. And since then, a lot of this data these questions have been added onto the CPS that ask about, are you in an occupation that is licensed? Is your license required for the work that you're in? Is there a training requirement to this? And in addition to this really excellent data, what Bobby and I did was we got some data from the American Bar Association that covered all of the state by occupation pairs for which there are restrictions on ex-offenders, to really look at this question as to whether there is this differential licensing premium by race and by gender, and what are the mechanisms that could generate this. And what we find is actually quite striking. So we're queued up. This is great. So I can click through. This is the research group here, and you can see Bobby here. I love working with students. Okay, so let me preview the results. So here are the headline results. So we find that licensing reduces the racial wage gap by about 43%, and what the mechanism here is that the license functions as a signal of non-felony status for African American men. And how we get at that is we look at licenses that have this felony restriction. We find that the gains are largest for African American men in those licensed occupations. We can also split the data by looking at the licensing premium for African American men in those occupations in states where there's ban-the-box regulation, meaning that firms are legally precluded from asking that information on the job application forms. And we find that the effect sizes of the licensing premium in those states is about 3 times as large. For women, what we find is that the license is conveying information about the human capital that women have. And so women, and in particular white women, benefit a lot from licensing requirements that have a human capital component to it. And we do like a ton of we have a novel way of controlling for unobservability, looking at occupational selection, then also dealing with measurement error. I know that time is short, so let me show you some of the key figures from our paper. Okay, so I'm going to show you several figures that look like this. And so on the horizontal axis, we have the certificate premium that we estimate. We have the licensing premium. And then this is for an ordinary license with no human capital component. And then we have the licensing premium for a license that has a felony restriction, and then one that has a continuous education requirement. The bars in blue are going to be with 3-digit occupation fixed effects. The bars in red are going to be with 6-digit occupation fixed effects. And licensing in the data is going to happen at the 6-digit occupational level. So this figure is for white men, and you can see that the licensing premium is around about 5%. And it's pretty similar whether the license has this felony information or a continuous education requirement. And it's not that different from the certificate premium. This is for white men. And so when we do that explicit difference between the licensing premium from the certificate premium, we see it's a precise 0 for white men. And so this was Milton Friedman's point, that a certificate really can be a replacement for a license, with this caveat specifically for white men. Now, when we look at African American men, the first thing that pops out to you is that licenses without any information about felony restrictions has almost no impact on wages. But the licenses with the felony restriction, I mean a huge impact, about a 20% premium. And we were shocked when we first found this. And so we've tried to beat up on this in several ways. Check out the paper if you want to get into the details of that. When we compare it relative to certificates, these occupations with the felony restrictions are also going to be conveying a lot more wage benefits to African American men, whereas the certificates, relative to the certificates, a license without that information doesn't convey as much. Now, let me pause here and say, we're not saying that licensing is a good institution. That's not what we're saying. What we're saying is it is an informative institution, and it's differentially informative by race and gender. I'll show you about 2 more figures, and then I'll wrap quickly because I know that there are others who need to speak. This is the figure for women. And so what you can see is that the largest gains for women are happening in these occupations where there's a continuous education requirement, right? And this is just the difference relative to certificates. For Black women, we see something that's similar as well too. There are just 2 more results that I want to show you, which is going to be, this is the licensing premium split out by ban-the-box states versus non-ban-the-box states, and split out again by race and by gender. And again, in these ban-the-box states, firms are legally precluded from asking about the felony status of workers. And so information is actively being removed from the labor market. So you can think about what Bobby and I do in this paper is we think about a context in which information about the felony status of workers is added to the labor market. And we're looking at whether that information is going to be differentially priced into the wages of workers. And what we can see here is that most of the action for Black men here in this red column is coming in these ban-the-box states. It's much larger than for white men, for white women, or for Black women. And when you look at the non-ban-the-box states, it's statistically not different from 0. Because in those states, firms have an easier way to access information about the felony status of workers. And so again, one of the key headlines from our paper is not that licensing is a good labor market institution, it's just that it's an informative labor market institution. Just like education can be a labor market signal, so can occupational licensing. And this is incredibly important for policymakers because when we think about reforming the institution of occupational licensing, we need to really know what are the full range of its effects. We need to also know who are the folks that are differentially affected by this. So that way we can incorporate for sharp policy analysis these sorts of changes. That's going to be really crucial. So that's one way that we hope policymakers will use our work. I just have... the other thing that we showed too is that this ban premium is decreasing by firm size. And so smaller firms are going to rely on the felony information in the occupational licenses a lot more than larger firms, precisely because they don't have really large HR firms. We do a whole host of checking for different alternative explanations, looking for unobservability, testing for measurement error, trying to see if this is really due to differential returns to education and hyper-selection of minority men on that. Differences in arrest rate, the fraction white in the occupation, whether it's just one specific panel in our time or if it's the whole time series, we do a lot of things there. And I just want to finish up with a discussion of some of the policy options. So one could be just to completely eliminate licenses and replace it with certificates. What we see is that will work particularly well for one demographic within our group, but maybe not as well for others, right? And that's a trade-off that as a society we have to think about. The second one could be to promote reciprocal licensing across states. And I know that there's a pact of 11 states in which that is being pursued. We have to think really carefully about how we do that because there could potentially be multiple equilibria. You could have a situation in which we equalize upwards, whereby all of the states now become California, or we can have a situation in which we equalize downwards and all the states become like Wyoming, which is one of the least licensed states. Another one is to make licensing at the state level non-binding. And so Darwin mentioned this, and I think that this is a particularly promising one. because there's something about the official nature of the license that's really important. In the absence of the government-issued credential, you can have a proliferation of certificates, which could increase the noise to signal ratio. Right? I could have a certification for plumbers, but I know nothing about plumbing, right? So there's something that's valuable about the official nature of it, but at the same time, to maybe not have it as a barrier to entry. And I'll end on this note and then pass the baton. So there are these certificates of qualification for employment for felons that judges can issue to ex-offenders, and those have been shown to be very helpful to helping ex-offenders get housing. So we can perhaps think about things like this that have the official nature of the state, that help with the rehabilitation process, but that are potentially less onerous than an occupational license. Again, this paper is on our website. It's also an NBR working paper. And I just want to give a shout out again to Bobby, who is my co-author and student that's on the job market. Thanks for your time.
Thank you, Peter.
I like to start on some very firm foundations. So number one, as in your program, my name is in fact Daniel Gilman. Number two, I do work at the Federal Trade Commission in the Office of Policy Planning. Number three, if you want to reach me to send me research results, to chat about this or that, to ask more about what we do, it's dgilman@ftc.gov. You can search me on Google. Don't just put in Daniel Gilman, because there are much more famous Daniel Gilmans, like Daniel Coy Gilman, the first president of Johns Hopkins University. No relation. But maybe Daniel Gilman in antitrust or Daniel Gilman in FTC, and you'll find me. Morris knows how to find me. Number four, and this is really true, stuff I say here today is stuff I say here today and does not necessarily represent the views of the Federal Trade Commission or any individual commissioner. So that's the true and clear stuff. What else? What do we do? I work in the policy shop, the Office of Policy Planning, in an agency that by its establishing statute has a law enforcement mission on the competition side, antitrust, and on the consumer protection side, in a particular sense of consumer protection, sort of quasi-anti-fraud work, and a statutory research mission, research, education, and advocacy. Initially, as conceived, the Federal Trade Commission was going to be sort of an expert agency on industries and markets and a resource for other lawmakers, other policymakers. By the time we got created, we were a law enforcement agency. We have sort of tertiary responsibility as a regulatory agency. I would say tertiary, some of it under our general authority, some of it under very special statutes like the Fairness to Contact Lens Consumers Act or the Children Online Protection Act. So on the antitrust side, we have both a law enforcement purview ranging over most of the economy, subject to certain carve-outs. So we regulate non-bank lenders, but not banks proper, at least not insofar as they're banking. We have a research and advocacy mission. We've done a fair bit of work on occupational regulation, both in terms of economic research and also in terms of policy work, advocacy, a lot of what I do is trying to translate what people have learned, Morris and others have learned about certain kinds of regulatory restrictions and their impact on competition and innovation for policymakers. We've had some measure of success. A lot of that I've done in healthcare sectors, and some of our concerns there have been about licensure as opposed to some other form of regulation or as opposed to no form of regulation, but very often we're concerned with marginal effects of more or less stringent licensing restrictions. So for example, we have people here affiliated with the nursing profession, advanced practice nurses. Morris and colleagues have done some empirical research on regulatory restrictions on more or less stringent limits on what advanced practice nurses can do and under what conditions. Some FTC economists have done research and still are doing research on this too. Tom Koch is doing some research. And so we want to know about the implications of that research for policy and for law enforcement. We've had cases regarding exclusionary practices, we've had a whole lot more advocacy where we try to provide information. Our framework is a little different, which maybe translates into, I suppose, a request. So we, let's see, as an institution, we have a Bureau of Economics. We're not a huge agency. We've got a Bureau of Economics with about 100 people working there. About 85 of them have PhDs. Most, not all, applied or empirical economists. About 2/3 of them sort of an industrial organization framework, competition framework. About a third consumer protection framework. Some people are trained in labor economics and they retool for one reason or another. But one interest here, I think, is, something some of you have done in the room and something certainly that Morris has done to some extent is translating some labor-oriented research into terms significant for competition analysis, whether we're bringing a case or whether we're doing policy analysis, kibitzing, what have you. So wage effects are interesting, but we're interested in consumer welfare. That's sort of our purview, so we look at consumer impact. So wages in most cases are a production input for services or goods. We want to know about restrictions that increase the price of goods or the quality adjusted price of goods. We want to know about restrictions that suppress output. We don't care so much directly about the labor effects. And so, one thing we want to know about with the wages is the larger picture. So we want labor policies that diminish racial discrimination in employment. I think labor economics has been working on this longer than I've been alive. My dad did doctoral dissertation research on this, and then after I was born, published something in the AR in 1965 on this. We continue to chip away at this, but so what's the effect on the differential? What's affecting on the wages? What's the effect not only on those people who enter the licensed occupation, but those people who are unable to enter the licensed occupation? What about the substitution of various services? Certainly there are, whatever demographic we're looking at, there are people who enter and maybe benefit more or less relative to what they've invested. There are people who don't enter, fail to enter. What's the impact on them? And then, of course, there are consumers across the board, typically a larger number of consumers. What does this do to prices, availability of services? If we're talking about healthcare, what does it do to access to services if we have distribution effects? And then, of course, I think for the data and for the analysis, how do these categories cross-cut each other? Regulations frequently at the state level, markets and market competition may not be at the state level, maybe very local, maybe national, et cetera. Where do we find competitive effects? How can we demonstrate them, show what's durable, show what can be addressed efficiently? And I think that's it.
Just to give you the publications, most of this is coming from a Hamilton Project policy proposal that my co-author Kathleen and I put together, and that stemmed from our earlier work about certified nurse midwives. So what are scope of practice laws? Well, it's the legal authority given to these licensed health professionals to provide medical care services within a state. And so basically it comes almost after the licensing. What these laws do is they really tell you what the practitioners can and can't do within that state. They generally govern practice and prescription authorities, but they're going to differ for all the different types of healthcare practitioners. Generally, physicians don't have scope of practice laws specifically like the other groups do. I'm going to focus most of this talk on the advanced practice nurses, but a lot of the lessons here can be attributed towards the physician assistants and some of the other groups. But just to give you an idea about what these laws really are and how they work, so for these nurses, these are the nurses with the master's degree, so they're advanced practice. Depending upon what state you live in, you may have to practice with supervision by a physician. you may have to practice collaboratively with or without protocols. And what a protocol is basically a piece of paper that says exactly, you can take x-rays, you can prescribe this drug for this condition, and so on, okay? Or you may be in a state with absolutely none of these requirements, and it says you've got your license, you've got your nursing degree, you can go and practice, okay? And then there's similar restrictions about prescription authority. Okay. Right now, the trend in the states is moving towards what we call this fully authorized scope of practice, which basically is the no specific requirements. It allows the nurses to practice to the full extent of their training and license without any physician oversights. And I do want to mention, though, that it is professional norm for nurses to work in collaboration with physicians. What we're talking about here is the state legislative, you must do this with physicians. Okay. This is a map from about the end of 2017, basically showing you which states have moved to fully authorize and which ones haven't. Now, within the gray, there's lots of variation about the degrees of independent practice. But the green here are the ones where the nurses are fully authorized, and Illinois actually just moved to that last year. The scope of practice laws are highly controversial. You know, we have these frequent legislative battles all the time. National Conference of State Legislatures actually reports 139 bills introduced in 2017 with 37 enacted. Typically, it's one practitioner group versus another, and the argument centers on quality, with, of course, one of the arguments being that you need the supervision to protect the patient health, and the counter argument being that the quality care is similar, and there's potential to reduce costs and increase access. Okay. What we show in our work is it's much more than a quality issue, and SOP has implications for all of these different factors, and I'm just going to talk about a few of them briefly. So with employment, you know, there's the big issue about the labor supply. You know, we like to think about what happens under a restrictive environment where having what you can and can't do dictated by the state legislature or by your supervising physician can really discourage people from either entering, from practicing, and there might be migration to other states. On the demand side, you know, we need to consider how all these laws affect marginal productivity. You know, there's a lot of details in these laws that say there has to be claim review, that results of tests can only go to the physician, not the nurse, and so there's delays in care. So all this affects productivity. We want to consider the substitutability among workers. And then there's also the idea that if you have these fully authorized scope of practice laws, you can actually encourage opening of new healthcare facilities, like the retail clinics that we've seen the growth of a lot over time. One of the things that has particular implications, particularly for the labor supply, is that some of these states have restrictions on ratios. Okay, and so these are the states that I found here, and the numbers of nurses that each physician is allowed to supervise. And this effectively puts a cap on the number of nurses that can practice. Now, these are, you know, with qualifications, right? I'm talking about there's exceptions for public health communities and some hospitals and so on. But if you're thinking about a nurse-opened practice in a rural area in Alabama, you have to have a supervising physician, and each physician can only supervise up to 3 nurses. So we effectively get these quotas going on here. All right, so from the academic literature, you know, people have been studying this issue. It's not a huge amount of literature out there, but we certainly see some trends. And what we see is that looking at these fully authorized or these independent scope of practice is that we do get higher rates of nurses working, particularly in rural areas. We see some reductions in shortages. We see some small increase or maybe no change in hours worked. I believe that's Morris's work there. We have some migration. So if you have prescription authority, you're less likely to move. My own work on the certified nurse midwives, we didn't see any employment changes associated with the degrees of restrictiveness of the laws, but I will caution that some of the data on employment for these nurses, the midwives, is pretty poor. The implications for healthcare utilization and access, again, we see some very positive stuff going on with these fully authorized scope of practices. I mean, you can read, but basically, you see a lot more use and desirable outcomes here. In terms of outcomes, right, health outcomes, this is the big argument from the going on legislatures from the physicians group. We actually see no evidence of harm to patients associated with the degrees of restrictedness. So there's really no difference if you're in a highly supervised state or a totally independent state. And this list here is just some of the outcomes that people have studied. And we actually see some slight improvements when we do have the fully enabled SOP. In self-reported health status and in my own work, we found fewer labor inductions and C-sections. And so all this can also translate into some savings, cost savings. This is always a big issue in the United States about the rising cost of healthcare. So we see some research here showing reductions in prices of child welfare visits, some lower payments from insurance in retail clinics. We have some reductions in claims from Medicaid patients. All of these are associated with the expanded or the fully enabled SOP. Now, I will also mention that within Medicaid and Medicare, since they set the reimbursement rates for practitioners, the fee schedule for most of the advanced practice providers, so the nurses, the PAs, are set lower than the physicians. And so if you see a substitution from a physician to a physician's assistant, you automatically get some cost savings there because they're reimbursed at 85%. We don't have too many estimates about total healthcare expenditures because, of course, we're going to see prices falling and we'll probably see quantities rising as you expand the labor supply here. We have a couple estimates of some long-term savings that I've shown up here. There's some other considerations that we've identified. We talk about innovation in healthcare. So with accountable care organizations are some of the new types of healthcare delivery models that are going on. And so some of these supervisory requirements are going to run counter to these goals of the program. We're also going to start to change incentives for physicians to enter into these types of things with the new delivery care model, so we have to watch out for that. I've already mentioned it has implications for growth of retail clinics. Telemedicine is actually a big one here because if you cross state lines, you're going to have to follow the scope of practice, I believe, of where the patient is and not where the provider is. So there's some legal issues there. And then finally, another potential issue is with malpractice liability. So when the physician supervises a nurse, most of the malpractice actually falls on the physician. But once you move to the fully enabled, if the nurse practices independently, then he or she would get the malpractice. And so that would actually alleviate some of the pressure on the physicians. So these are just some of the considerations. This is actually all in our policy proposal. And this is where we end up with this, is that we really find full support that any state that hasn't done so already should really pass legislation to reduce the physician oversights and enable these practitioners to practice freely in collaboration, but without the administrative barriers to care.
Thank you, Sara.
So my name is Al Downs. I'm with the National Conference of State Legislatures. The other panelists have mentioned my organization. For those of you who are not familiar, NCSL is a national bipartisan organization that serves every legislator and staff member in every legislature in all states, commonwealths, and territories in the country. We are a bipartisan organization. We're not making recommendations for states to change policy. We're just facilitating those conversations, making sure that the research of the fine folks like you gets into the hands of the folks who need it when they need it, and also our hope is that we, maybe even point them in a direction that they didn't know that they needed to look. So we began our project on occupational licensing following an award from the U.S. Department of Labor under the Obama administration. We have won additional grant funding to continue our research into occupational licensing under the Trump administration. And we partnered with the National Governors Association and the Council of State Governments to work on this project. we have been doing is in working with policymakers across the states is providing research aggregation of the kind of primary and secondary research that folks like yourselves are doing. We put together literature, scans, and reviews in ideally easily digestible formats for folks who may not be dealing in the academic world on a daily basis. Legislators often are confronted with dozens of issues at a time, so our hope is that we can translate some of the really great academic work into something that's accessible to them. Last year we put out kind of an overview state of occupational licensing report that looked at kind of broader topics within occupational licensing. And this year we published a series of reports looking at the research that existed on the impacts on employment for four specific population groups. The first of those being individuals with criminal records, the second being the long-term unemployed, the third being immigrants with work authorization, and the fourth being, I said folks with criminal records, I apologize. Veterans and military spouses is our fourth population that we took a look at. So in addition to putting out those kinds of reports and offering kind of ad hoc technical assistance to legislators and staff when they have questions about what research is available, we also have put together two major databases that we hope can be useful for researchers and policymakers alike. The first of those is our Occupational Licensing Requirements database, where we have cataloged the cost, education, number of years required, whether or not there are blanket bans on folks with criminal records, good moral character clauses included in statute and regulation, and several other variables across 30 occupations, and we're adding to that number of occupations, and that is for all 50 states. That is all available publicly on our website, and we hope to expand that data set and make it available to people as they compare licensing requirements across states and even across occupations within the same state. Our second major database is a legislative tracking database, and Sara mentioned that in our scope of practice legislative tracker, she took advantage of some of that data. For our occupational licensing legislation tracker, we aggregate all of the legislation that is introduced in all the legislatures of the 50 states and all the territories and other state-level governments, and compile them in a searchable format based on either the occupation that they're covering, the type of reform being pursued, whether it is a board restructuring, if it's the creation of a new license. There's several different tools to look through that data. So that's kind of the research component of our project. The other major component is, and this is another piece that was briefly alluded to earlier, is our 11-state licensing policy consortium. We had, at the beginning of our grant project, we had a competitive application process through which we selected 11 states to participate in kind of a more in-depth series of technical assistance meetings that NCSL, along with our partners at CSG and NGA, are facilitating, where we bring together these state policy teams, typically between 5 or 10 folks, legislators, members of the executive branch. Mischa Fisher yesterday was at the Illinois State meeting. So it's to bring these folks together to talk about what is important in their state to addressing licensing policy, what changes should be made, how they should be thinking about those changes, and bringing in outside experts who may have a particular expertise in what the states are looking at doing. In addition to the kind of individual state meetings, we have national meetings of the consortium where states come together to share practices, to discuss what kind of changes they've been seeing, what roadblocks they've faced, what steps they've been taking, as well as hear from even more national experts and try to keep these folks up to date on the most recent research and conversations that are going on among licensing policy experts and economists. So just real briefly, I'd like to talk about some of the findings that NCSL has found in our year and a half of working on this project. So from our legislative tracking base, we have some quantitative evidence about what steps states are taking to make licensing policy changes. I think the kind of broadest broadest measure that we can look at is over the last year, 61 pieces of legislation across 24 states were enacted to either reduce licensing requirements, expand the options for meeting those requirements or for creating waivers for certain requirements in licensing. I think that number in and of itself demonstrates that there's significant interest. Almost half the states in the country were looking at this and actually enacted something in the last year. If we take a step back to look at kind of just proposed legislation, that number gets even larger. Some of the most significant interest that we see and kind of hear anecdotally, but also see bore out in the legislation being introduced is a movement towards increasing sunrise and sunset reviews, regulatory impact reviews, specifically for licensing that comes up. Not every state is as lucky as Illinois to have a brilliant economist on staff who's actively engaged in the licensing policy. And one of the big struggles that we hear from states is how can they quantify the costs and benefits of these licensing rules? Often these laws get enacted before a very thorough analysis of what the costs and benefits will be. So that limitation is something that many states are struggling with. In the last year, we saw 9 states propose or consider legislation to create some form of sunrise review for these licensing rules. To put that in perspective, there are only 10 states right now that actively perform sunrise and sunset reviews of licensing regulations and laws when they're proposed. So had all of those states enacted that kind of review, it would have nearly doubled the number. In many of those cases, the legislation moved through one house but not through the other, and I think we will expect those to come up in the next legislative session as well, and more states will be moving in that direction. Kind of in that same vein, as states are thinking more critically about licensing proposals as they come up, we're seeing a larger number of new licenses being rejected. 2/3 of the new licensing proposals that came up around the country last year failed, which is a 12 percentage point increase over the past 2 years before that, the average of the past 2 years before that. So we're seeing state legislatures being more hesitant to enact new licensing laws, which is obviously the main mechanism by which licensing laws are growing across the country, is that you have legislatures continuing to enact them. But our data shows that rate is at least slowing. I think lastly, what I would like to say is that, and this is again kind of more anecdotal evidence, but the states that are engaged on this, there's a varying level of education and an understanding of the issue. I think earlier it was discussed how many folks kind of view occupational regulation, at least in the United States, as a binary choice between either no regulation whatsoever or licensing. And I think what we see is many legislators kind of viewing that as the only option in front of them. And many are not comfortable moving with delicensing of a whole host of occupations. And as conversations continue, as we bring in the experts and researchers like yourselves to speak to these legislators, the understanding of the issue continues to grow. The level of nuance in the conversations about what policy direction is most beneficial to the states just becomes more and more sophisticated. And I think being in the second year of this project, we've seen an enormous amount of development of clarity in the direction that these states want to go. Obviously, every state that applied to be a part of the consortium had at least one state legislator or one member of their Commerce Department who was really excited and animated about licensing and put together the application. But we're getting to the point now where really everyone on all of these teams is engaged, is thoughtful about the direction that they want to go, and is willing to work with everyone else in their state to come to some kind of direction on licensing policy moving forward. So with that, thanks so much for including me, and look forward to answer your questions.
Thank you very much, Al. And like the previous chairs before me, I will also exercise my prerogative in asking the first question. We have about just under 20 minutes for audience questions after I ask mine. And I'm glad that Al actually ended the way he did, because my question relates directly to that. And as it was mentioned, much of the historical thinking about occupational licensing is as a binary status, and we see that reflected in a lot of the graphs that we saw this morning. Just due to the nature of the data collection, it was enough of a struggle just to capture whether an occupation in a given place is licensed at all. But the conversation we've just had has illustrated that that's probably not the best way to think about it, either in terms of research or policy making. And for that, we saw 2 different instances where licensing and the effects of licensing may be differentially functioning as a screen, that it's actually guaranteeing that workers pass a certain bar, and that's where the effects are really biting. But in other cases, it may be on a limitation of tasks that can be performed in the sense of scope of practice, often in medicine, but that may be true in other occupations as well. So I'm going to kind of take what Al asked at the end and open that question up to everybody. Basically, in each of your own experiences, either as a researcher or as a practitioner, how important is this range in what licensing entails, both across occupations and across geographies, for considering policy rather than the presence of licensing itself?
I guess we can go down the line. So far, irrelevant. It has not been a relevant factor. I mean, Illinois is pretty binary. That being said, the framework of having these alternative oversight regimes is an extremely useful one going forward. And we've got a bipartisan Sunrise effort that is pending for final action by the legislature. And that has authored into it that for a part of our Sunrise process, which would be economists digging into labor market dynamics, taking a year to work on it, and really trying to monetize the costs and the benefits of licensure, that they would also have to price in the alternative regimes in terms of certification and just pure market competition and everything that I suspect most people in the room are familiar with from Dick Carpenter's work.
So a lot of the heterogeneity in licensing actually comes from really good data collection. So the SIP is a fantastic example of that, where in the SIP what we can see is there a human capital component? Is there a certificate that somebody has? Where has it been issued? And so I think as we begin to ask a lot more questions of folks, we can really capture licensing being more of a continuum as opposed to being a binary. Now, connecting it to the results of the paper that I presented, that's joint work with Bobby, what we find is that there's huge heterogeneity in these effects, and the heterogeneity comes in by the types of licenses. So for example, for African American men, like there's a huge benefit to a license that is able to signal a non-felony status, but there's almost no benefit to a license that does not have that information, right? And so there's huge heterogeneity across the population as well too. And again, let me just reiterate, that's not saying that licensing is good, but we really have to think about how can we provide more resources for the data collection. And so I'm really happy about the efforts that your organization is doing. And as researchers like start to think about how do these various components of the occupational license apply potentially differentially to people based on their own demographic characteristics or where they live as well. So I think a lot of the heterogeneity is there. And we hope that our work is really going to help to encourage other researchers to really think about how do we use these existing features of the license and the coverage of who's affected by that to get at this binary versus continuum.
We've looked at a lot of things in different contexts. I mean, we tend to be plotters, or as computer scientists would say, bottom up. We look at what particular conduct, particular proposed mergers, particular regulatory restrictions, and ask about marginal changes. First of all, is there some substantial exclusionary effect, right? Second, does this suppress output of services in some sort of meaningful way? Does it raise prices, raise quality-adjusted prices? Third, we then come around to asking whether they're offsetting benefits. Frequently, there are benefits, maybe not necessarily offsetting benefits, but there may be. So I think we found substantial heterogeneity. Sometimes in the policy context, we've asked, for instance, whether there's some good, even prior justification for saying that something requires a license. Farriers doing the floating of horses' teeth. It's usually service-oriented, right? So it's not just does an occupation require a license, but does the provision of a service require a license? Interior design, exterior design, landscape design. We had a case. Actually, IJ had a very nice case. They argued on constitutional grounds. We provided some amicus support based on our expertise and some obscure thing that we have called the funeral rule, but also I wrote a couple paragraphs of sort of competition analysis. There was a case in Louisiana. They wanted to require. They basically were going after some monks at an abbey, St. Joseph's Abbey. They were doing something really horrible. They started making their own caskets, plain pine wooden boxes with a cross on top, first to bury members of the order. Then it turned out some religious people in Louisiana wanted to buy these things. The funeral business didn't like it. There was a rule that said they needed to have they needed to be funeral direct. They needed to be licensed funeral directors. Licensed funeral directors had to employ licensed embalmers to do this. They didn't happen to have these facilities. I mean, there were some sort of primary crude health indications. It turned out everybody buried in one of the monks' caskets was deceased. You know, you could think, well, maybe they make them out of lead. No, and in point of fact, there was no requirement in Louisiana that they made them, but
I want to make sure everyone else still has a chance to answer, and people.
Oh, yeah, sorry. So we look at the particulars, and the categories are useful, but sometimes not necessarily the most useful thing, because certification criteria can be big and licensure criteria can be relatively small. The relative benefits, informational signaling, whatever else comes with it, can vary tremendously. So we have some general stuff, but we tend to go matter by matter, restriction by restriction.
As an empirical researcher, I highly value variation, but in this case, the variation in the scope of practice laws across states, it makes just even the categorization, very difficult, right? You can go to 3 different sources and get 3 different answers about what the state laws are. We actually hired a lawyer to help us to really figure out what was going on within these states, because you can have some states that mandate a supervision practice, but there's nothing behind it, and so effectively they're practicing independently. So there's all these nuances to these scope of practice laws. The one benefit about the states all moving towards this fully authorized is that it will help mitigate some of these cross-state problems. We can have freer labor migration, and it will help with telemedicine.
And just quickly, I will add that the states of Tennessee, Mississippi, and Arizona in the last couple of years have actually added into their occupational licensing review statute that the inverted pyramid developed by the Institute for Justice be considered, that sort of spectrum of burden be kind of the guiding light as licenses are considered in those states. Another example of a state that has sort of thought along that spectrum in recent years is Wisconsin. They don't have it in statute explicitly, but there were a series of licenses being requested from folks like art therapists and horse massage therapists, horse masseuses, and the state of Wisconsin, their kind of compromise there was to say we'll have a non-mandatory certification available from the state for these occupations.
All right, thank you very much. And we have about 10, 12 minutes left for questions from the audience. Derek.
Peter, this is just a suggestion. There's evidence is few and far between about signaling being valuable. And, we had this JP paper with Clark and Mortel where getting the high school diploma because you passed the exam was worth nothing in Florida and Texas. So your results very striking. I think what would make it even more compelling is to take a stand on the exact signaling model that you think is at work, solve for the equilibrium, and then trace out the quantities. I think you're going to have restrictions on holding constant education and the fraction of people with a past record, the relative employment of black and white men in different types of jobs in different types of states. And if you get the quantities to match up with the prediction of your model, that will bolster your interpretation of the price effects.
Yeah, thanks a lot for that point, Derek. And so we have a separate paper that's going to be coming out in an edited volume that Emory has that looks at the quantities. And so there's no free lunch here, right? So effectively what happens is you do see negative employment effects, particularly for men. We need more precision to see if it's differential for African American men because it's pretty imprecisely estimated in these occupations with the felony restrictions. But yeah, there certainly is no free lunch here.
Yes.
Peter, now your mechanism doesn't really require licensing, right? Certification would accomplish the same. Do you have any chance to evaluate whether that holds up empirically, and that a certification for not having a felony record, presumably under your mechanism, would accomplish the same result?
Yeah, that's a good point. So these like certificates that are issued to ex-offenders have been by judges have been shown to have really positive.
Or just take whatever you have as a license and say to get the certificate you need the same lack of a felony record that you needed to get the license.
Yeah, I completely agree. And the way to think about our paper in the light of what you're saying is what we're pointing out is that the license is adding this really valuable information to the table that we previously did not know. And so when we think about potential remedies, the licensing may not be the most cost-effective way to do it. And we're completely open to that interpretation to look at alternatives that are less costly. But what we will take a pretty strong stand on is saying that that information is really important, and our result is showing that the labor market is pricing that into wages.
Questions for other panelists as well? Sally, did you have one? Nope. Yes.
This is a question for all. Has NCSL considered offering best practices in relation to or templated format for sunset and sunrise reviews? Because I've been looking at sunset and sunrise reviews recently, and the problem is that you look at one review, you've looked at one review, they're all over the place. There's no standardization, and even within a state, you can't actually transfer learning from a review that's in a related profession.
So, as I mentioned, NCSL represents every single elected legislator in the country. It's a bipartisan organization. Getting them to agree on anything to allow us as staff is very difficult. So we do not offer best practices, just kind of on the basis that our membership doesn't agree on what the best practices are.
Another response?
Yeah, so there's an unanticipated effects issue here too. We have repeatedly advocated for ex ante review, ex post review, sunset review. What are the effects, not just on the occupation, but on consumers, on prices, supply, distribution of goods and services? Do they build in competitive effects? We've advocated, it's great when this gets done. There's this weird doctrine in the United States called the state action doctrine. And what this does is, by and large, immunize actions of the state as sovereign from federal antitrust scrutiny, and authority of the state sometimes is delegated to independent boards dominated by active market participants. Very frequently in the occupations, this is the true active and self-interested, and maybe even professionally biased, unconsciously biased participants. When do they get access to the mantle, not just of state power, but the protection and shield of the state action doctrine, is a complicated question. So one thing we sometimes worry about is, look, if you're gonna do this review and you don't do it right, and you don't have the right people do it with the right resources to really move policy in ways that enhance consumer welfare, that enhance net social welfare, you could, A, spend a whole bunch of money, B, do a little dance, C, immunize boards dominated by active market participants from federal antitrust scrutiny, even when they, as private parties, in a self-interested way, violate the antitrust laws in ways that demonstrably harm consumers. We don't love that. It's just something to pay attention to, and sort of unanticipated effect of a very generically useful and sensible thing, which is to say sunrise and sunset review.
And I'll just briefly add that I think that part of that problem that you mentioned is inevitable. Every state does licensing differently, so every sunrise is going to be a little different. And in some states, they've got pretty strict restrictions on what it is. Other states, the legislature might not give up that power. So I think that you will always, by definition, have dramatic differences there. I do think that there is room to have standardized methodology. And granted, I'm a biased party, but I think that what we've got drafted and that the legislature may adopt later this year provides a good framework for what the methodology looks like in terms of spelling out specifically what numbers you have to crunch and what elements you have to consider.
And we'll have time for 2 more questions, but I wanted to just say, and I'll apologize in advance for this, but passing a sunrise sunset provision may be as difficult as being a fiddler on a roof. Yes, back there.
It's my understanding that there's no correlation in research. It's my understanding that there's no research showing a correlation between a teaching degree and quality of teaching. For Mr. Downs, are there any states moving to eliminate a teaching degree certification, so-called, in favor of Einstein's without a teaching degree teaching science, for instance?
In terms of public schools moving towards delicensing of teachers, that's not something that I'm aware of. One thing to keep in mind for teacher licensing is that it's done by and large at the district level. So state governments, to the chagrin of many state legislators, don't have the amount of control over that they'd like. I'd also point out that as far as I know, every single state in the United States does not license private school teachers. It's only the teachers who are actual employees of some government entity, be it a school district or an individual school, that are required to be licensed, which kind of in and of itself presents a different issue than private sector employees when you're licensing them, because a teacher who wants to work at a religious school or any other kind of private school doesn't face those same barriers that someone who wants to work for PS 115.
Last question, Morris.
Thank you. Great session. So thank you. First of all, you've documented generally the costs of licensing, and certainly that seems to be fairly easy to do. If a legislature or a legislator said, yes, these are the costs, what would you have to show are the benefits for these new occupations that are becoming licensed? What would you ask them to show and what to overcome these documented costs of licensing?
Well, I guess,
and this is sort of a welfare economics question. So,
well, and it's interesting what I asked, because I answered that question in drafting the Sunrise proposal that we've got out there. And specifically what we said was the question has to be answered by an Illinois-based labor market economist. So we first that sets a certain way of looking at the problem. And then we specifically said you've got to look at the impact on those who benefit from the license. You've got to look in terms of wages, signaling, those sorts of things. You've got to look at their customers. You've got to look at that in the context of the overall dynamic system that is a labor market economy. And then you've also got to look at those locked out as part of that equation. And then you've got to take that effect, see how it plays out over the next 10 to 20 years, put a net present value on the whole thing, and then stack up all the options.
Anyone else would like to answer Morris's question?
Yeah, sure. I'll take a stab at that one as well. I think that the model developed in Illinois is kind of illustrative of the broader picture, right? That no two states will it be the same. What benefits matter to the legislators and to any of the policymakers making these decisions are going to be vastly different across states, and we see that obviously in our work. It was mentioned earlier that passing Sunrise is very difficult. And I mentioned that having best practices for Sunrise or any kind of regulatory review like this is also very difficult, precisely because there's so much I don't want to say quite disagreement, but different interests of the state legislators and of the state governments as a whole in determining what benefits they're looking for in licensing laws. You may have some states where it'll be explicitly laid out in statute that the licensing law is not solely to protect the public, but to protect the public and also promote the occupation or profession. And in those cases, obviously, the benefits being considered would be different than in a state where their only consideration is protection of the public. Or on the flip side, if the licensing law language says it's only for the promotion of the occupation, then the kind of review of that would be measuring costs and benefits differently. So I think the answer that is kind of a cop-out is there isn't an answer.
All right, I think we're just about out of time, so thank you very much. Let's give me a hand with the panel.